On June 23, 2026, the United States Supreme Court issued a new decision about homes sold after unpaid property taxes. The case is called Pung versus Isabella County. It does not create a new federal tax bill for every senior homeowner. It does not send a new payment to everyone over 60. But it does answer a question that can matter if a home is ever pulled into a tax sale. If the government sells the home, what value counts? For seniors who own a home, have a reverse mortgage, pay taxes through escrow, or are watching property tax bills rise as July begins, this is the part worth understanding. The overlooked detail is not the viral headline. It is the phrase surplus sale proceeds. Today we will explain what that means, who should pay the closest attention, and why this July warning should be treated as a check your records warning, not a panic warning. We will also cover the mistake many people make when they think a paid-off home is automatically safe, the documents to pull out this week, and the scam warning that matters whenever foreclosure fear is in the news. Here is the confirmed reveal. The Supreme Court decision was announced on June 23, 2026. The agency is the United States Supreme Court. The case came from Michigan, but the rule matters nationwide because it explains federal constitutional limits in tax foreclosure cases. The court said that when a property is sold in a fairly conducted tax sale, the Constitution does not require the government to pay the homeowner the home's full fair market value. Instead, the basic measure is the money from the tax sale after the tax debt is paid. That remaining money is the surplus. Let us say that in plain words. If a county sells a home because of unpaid property taxes, the homeowner may have a right to the extra money left after the taxes, penalties, interest, and allowed costs are paid. But the new decision says the homeowner is not automatically entitled to the higher price the house might have brought in a normal private sale. That is the key point. It is not about a new July tax. It is about how much protection remains after a tax sale has already happened. This decision sits on top of an older Supreme Court decision from 2023 called Tyler versus Hennepin County. Tyler said a government cannot simply keep more than it is owed when a tax sale produces extra money. Pung answers the next question. If the auction price is lower than the home's market value, can the owner demand market value instead? The court said generally no, at least when the sale was fairly conducted. That phrase, fairly conducted, is one of the biggest details to remember. Think of it like a monthly bank statement. Your statement shows deposits, bills, fees, and what is left. In a tax sale, the auction price is like the deposit. The tax debt and legal costs are like the bills. What remains is the surplus. The question in Pung was whether the statement should also include money that was never actually deposited, meaning the higher market price the home might have received somewhere else. The court said the Constitution does not usually require that. This matters because many older homeowners are house-rich but cash-tight. You may own a home that has grown in value over 20, 30, or 40 years, but your monthly income may be Social Security, a pension, disability benefits, part-time work, or savings. Your home can look valuable on paper while your bank account still feels tight. Property taxes, insurance, repairs, and association fees can rise faster than income. That is where danger can begin. But let us be very clear. The Supreme Court did not say counties can do anything they want. The court did not erase the 2023 Tyler protection. It did not say a fake sale is fine. It did not say a sham auction is fine. It did not say every local process is safe from challenge. The case was sent back for more work on remaining issues, including questions about the process. That is why the word fairly matters. If the sale process was unfair, the legal analysis may be different. Now let us bring this back to senior homeowners 60 and older. The decision is not limited to seniors. A younger homeowner can be affected too, but seniors deserve special attention for 3 reasons. First, many older adults own homes with years of built-up equity. Second, many live on fixed income. Third, some older homeowners no longer have a regular mortgage payment, so they may pay property taxes directly and may not have an escrow account reminding them each month. The first group that should pay close attention is anyone who is behind on property taxes, even by a small amount. A small unpaid tax bill can grow because of interest, penalties, fees, and time. Do not assume the amount is too small to matter. The second group is people with a reverse mortgage. With the most common reverse mortgage, called a home equity conversion mortgage, you still have responsibilities. You must pay property taxes and homeowners insurance, keep the home in good repair, and live in the home as your main residence. If you fall behind on taxes or insurance, you can face serious problems, including foreclosure. The third group is people who pay taxes through a mortgage escrow account. Escrow means your lender or servicer collects part of your monthly payment and is supposed to pay property taxes for you. But errors can happen. If you receive a tax bill or delinquency notice, even though you thought your servicer paid, do not ignore it. Contact your servicer and the tax authority quickly and put the issue in writing. The fourth group is heirs, widows, widowers, and family members handling an older property after someone dies. Tax notices may go to the wrong address. A family member may think another person is paying. Months can pass before anyone notices the problem. This is one reason old homes can get pulled into tax trouble. The people least affected are homeowners who are current on taxes, have no lien, have no tax sale notice, and are only hearing a scary online claim. Also, renters are generally not affected by a homeowner tax sale rule, though some states have renter rebate programs. And this is not a new federal stimulus check, not a new senior bonus, and not a new automatic property tax exemption. Let us look at a simple example. Imagine a woman named Linda. She is 68. She paid off her mortgage years ago. She loves that she has no monthly mortgage payment, but that also means she pays her property taxes herself. One year, her tax bill rises, her insurance rises, and a medical bill uses up part of her savings. She misses a property tax deadline and thinks, I will deal with it after the holidays. Then a notice comes. It uses legal words. Linda feels embarrassed and puts it in a drawer. Later, she hears online that the Supreme Court says the government must pay full market value if a home is sold. She feels safer than she should. The correct lesson is different. The better step is to call the county treasurer or tax collector right away, ask about payment plans, hardship options, senior exemptions, and deadlines, and keep a written record of every answer. If Linda waits until the sale happens, her options may shrink. If there is a sale, she may be able to claim surplus money if the sale brings in more than the debt. But she should not assume she will receive the full appraised value of the house. Real results depend on state law, the sale process, deadlines, and the facts. That is why the safe move is to act before the sale, not after. There is another important July detail. Many property tax programs are local or state programs, not federal programs. In some places, July is a deadline month for senior exemptions or property tax applications. In other places, the deadline already passed, or it comes later in the year. Some programs use age 65. Some use age 62. Some use disability status. Some have income limits. Some require you to own and occupy the home as your main residence. Some renew automatically after approval. Others require renewal. So the question is not, do all seniors get the same July benefit? The better question is, what does my county or state require before the deadline? That question can save time, money, and stress. There is also the Homeowner Assistance Fund. It was created to help eligible homeowners who were financially affected by the COVID-19 pandemic with housing-related costs. Depending on the local program, help may include mortgage payments, property taxes, homeowners insurance, utilities, or certain other housing costs. But the money is limited, and programs depend on where you live. It is scheduled to end in September 2026, or when funds run out, whichever comes first. That does not mean every person qualifies. It means people who are struggling should check the official program in their area before assuming help is gone. Now let us walk through the action steps slowly. Step 1. Find your latest property tax bill, your assessment notice, and any letter from your county, city, township, or tax collector. Do not rely only on memory. Look at the year, the parcel number, the amount due, the due date, and whether it says delinquent, lion, forfeiture, tax sale, foreclosure, or redemption. If you see any of those words, treat the letter as important. Step 2. Confirm whether your taxes were actually paid. If you pay directly, check your receipt, bank record, or canceled check. If your lender pays through escrow, check your mortgage statement and contact the servicer if something looks wrong. If the tax office says the bill is unpaid, ask for the balance in writing and ask what date matters next. Do not post your parcel number, social security number, account login, or personal documents in a YouTube comment. Step 3. Ask about senior property tax relief before you assume you do not qualify. Call or visit your county assessor, tax collector, or state tax office. Use the official agency, not a random ad. Ask whether your area has a senior exemption, homestead exemption, freeze, circuit breaker, deferral, hardship plan, or installment agreement. Ask the age requirement, income limit, residency rule, documents needed, and deadline. Write down the name of the office, the date, and what they told you. Step 4. If you are already behind, ask for help before the problem reaches sale. A HUD-approved housing counselor may be able to help you understand options at low or no cost. If you do not use computers, you can ask about phone or in-person help. For reverse mortgage borrowers, ask for a reverse mortgage housing counselor right away if you cannot pay taxes or insurance. If you receive legal papers or a tax sale notice, legal aid, or a lawyer may be needed because deadlines can be strict. Step 5. Save every record. Keep the envelope, not just the letter. The postmark can matter. Keep receipts, screenshots, payment confirmation numbers, names of workers you spoke with, and copies of forms. If you mail anything, consider a trackable method. If you hand deliver a form, ask for a stamped copy or written confirmation. Good records can be the difference between a clear solution and a confusing argument later. Step 6. Do not wait for someone to knock on the door. A paid-off home can still be at risk if property taxes are not handled. A reverse mortgage does not remove tax and insurance duties. An escrow account does not mean mistakes are impossible. And a Supreme Court case does not replace your local deadline. The safest time to act is when you first see a notice, not after a sale date is set. You may be thinking, I do not understand legal papers. That is normal. Many notices are written in hard language. Look for the agency name, the amount, the deadline, and the action requested. Then call the official office listed on your real tax bill, not a number from a social media comment. You may be thinking, English is not my first language. Many agencies have language help, and housing counselors may be able to explain the process in simpler words. Ask for language assistance when you call. You may be thinking, I already applied for an exemption years ago. That is good, but still check. Some areas keep the benefit until you move, sell, pass away, or no longer qualify. Other areas require renewal. A small missed renewal can turn into a larger bill. You may be thinking, my children handle my papers. That can help, but you should still know where the documents are. Make sure trusted family members know the tax due dates, insurance due dates, and mortgage or reverse mortgage responsibilities. Do not give account passwords to people you do not fully trust. Before we finish, there is a serious scam warning. When a scary court decision or foreclosure story goes viral, scammers use fear. They may claim they can stop a tax sale overnight. They may promise a secret senior homeowner refund. They may say you must pay with gift cards, crypto, wire transfer, or a payment app. They may pretend to be a government worker and ask for your social security number, bank login, or deed information. A real government agency will not need your online banking password. The FTC also warns that it never requires people to pay money or provide account information to get an FTC refund. So slow down, verify the office, use the official agency contact, never put private details in the comments, and be careful with anyone who pressures you to sign your deed, transfer title, or pay before you understand the document. Now, what remains unclear? The Pung decision answers one federal question, but it does not answer every state question. State laws can give homeowners extra protections. Local tax sale procedures can differ. Some cases will depend on whether the sale was fair, some will depend on whether the homeowner met a claim deadline, some will depend on whether there was proper notice. And the Pung case itself was sent back, so lower courts may still deal with remaining issues. That is why the real July warning is practical, not dramatic. Check your property tax status. Check your exemption status. Check any escrow issue. Check any reverse mortgage tax or insurance duty. And if a tax sale or foreclosure notice is already in your hands, do not treat this video as your personal legal answer. Use it as a reason to get official help quickly. Here is the final recap. The confirmed update is a June 23, 2026 Supreme Court decision in Pung versus Isabella County. It does not create a new July tax for all seniors. It does not create a new payment for everyone over 60. It says that, after a fairly conducted tax sale, the Constitution generally looks to the sale proceeds, not the home's higher possible market value, when measuring what must be returned after the tax debt is paid. The people who should pay closest attention are homeowners behind on property taxes, people with reverse mortgages, people who rely on escrow, heirs handling a family property, and seniors who may qualify for property tax relief but have not checked the deadline. The most useful action today is simple. Pull out your latest tax bill and confirm your status with the official local tax office. The biggest safety warning is also simple. Do not trust anyone promising a secret refund, a guaranteed rescue, or a special senior payment for an upfront fee. Share this video with someone who owns a home and may be ignoring a tax notice. Subscribe to USALifeBulletin, turn on notifications, and come back for clear USA updates on Social Security, benefits, taxes, housing, immigration, and money.